This conference will now be recorded.
Okay, good afternoon. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our May 20th, 2021 public meeting. This meeting is being held via teleconference pursuant to Governor's Executive Order 202.1 due to the coronavirus emergency. Section 2 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of inter-multi-dwelling buildings from commercial and manufacturing spaces to self-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecute parties who violate the loft law and the loft board rules. So before I start, I have two short comments. First, we have a new board member with us today, and that's Ms. Nicole Otto. Nicole is a skilled financial executive and certified public accountant with over 15 years of experience as an accounting and operations professional. Her experiences growing up fueled a desire to help build power for working class communities, immigrants, and other vulnerable members of society. Among other notable achievements, including work at leading contemporary art galleries, Nicole began her career as an auditor and tax accountant for a wide variety of industries, including government contracting, nonprofits, food and beverage, real estate, and luxury retail. She further developed her nonprofit expertise in the role of Director of Finance and HR and later CFO at Make the Road New York, a multi-funded social justice organization with over 200 employees and sites throughout the New York metropolitan area. Nicole is excited to be back at a place where her work contributes to making people's lives better and is honored to join the New York City Loft Board. Nicole, do you want to just say hi and welcome, folks? Welcome, Mr.
Hi, Ronaldo. I'm just very grateful to be able to lend my experiences to helping support people, especially in New York. I've lived here for a long time, and really is something I enjoy doing. So thank you for having me today.
Thank you, Nicole. Welcome to the board, and there's a lot of work here, so I appreciate your hard worker, being a hard worker. All right, secondly, item number 8 on today's agenda will be a discussion of an active litigation matter against the Loft Board. The matter of Deezer Properties 2 LLC versus New York City Loft Board. So my aim today is for the board to consider this item after all other agenda items have been addressed. At that time, I will entertain a motion for the board to enter in executive session to discuss this matter. Okay, so we first turn to a vote on the minutes from the March 18th, 2021 public meeting. Before we vote, I have one comment on the March 18 minutes. So at the March 18 meeting, I, as chairperson, inadvertently announced the details of docket number LE0715. LE0715 was not on the agenda, on the calendar. And that intended case included docket number LE0722 and RG0211. And that case was the Broadway Corporate Group LLC at 496 Broadway in Brooklyn. So to be clear, documents for LE0722 and RG0211 were in fact presented to the board and voted upon. And LE0715 was not presented for discussion at the March 18th meeting. But the minutes from the March 18th meeting reflect the board's vote on LE0722 and RG0211. Is it any questions about that? This was just a naming. I just called the wrong case, and it was not on the agenda. But you debated and voted on the case, that's reflected in the minutes. All right, it was just a typo on my sheet, okay? Okay, so are there any comments or corrections to the minutes, apart from what I just mentioned? Mr. Delaney.
Thank you, Ronaldo. On page 4, I had asked a question with regard to resuming our enforcement efforts, and at that time, acting executive director Lynn pointed out that our enforcement attorney is out on leave, or at that time, but I see him in the room today, so I'm just inquiring, or either now or when the executive director gives his report, for an update on our plans going forward for enforcement.
Would you just leave that to Mr. Schultz, executive director's report? That's good, Mr. Delaney?
Sure.
Right.
Other than that, I looked as hard as I could to find at least one typo in this, and I wasn't able to. So, Ms. Ryan, congratulations. Yet again.
I thank you.
No hitter.
1 for Ryan, 0 for Delaney this week so far.
You're going to be up to 2 in a few minutes.
Perfection is our goal. Okay, very good. So without any other comments, is there a motion then to accept these minutes? Mr. Delaney and Mr. Bowers is second. Ms. Rivera.
Mr. Bowers.
Yes.
Mr. Roach.
I don't think he heard it. Mr. Roach, you're calling your name. Yes.
Yes. Yes.
Ms. Hayashi.
Is that Hayashi?
Hayashi, yes.
Yes.
Mr. Hilton.
Christian, are you there?
We may have lost him.
1 second. I wonder if Christian, if you are any one of these callers and I have you, 1 second. Christian, is that you?
Yes.
Oh,
Yes.
all right, could you mute yourself a second? Did you hear the vote on the minutes?
Yes, I did. Yes, I
Okay.
did. I heard everything. I've been
You're
on.
You're voting in affirmative for the minutes?
Yes. Yes.
Okay, very good. Let me just name you. 1 second. Let me just name Christian. I'm sorry, I had the Christian mute. Okay.
Mr. Delaney.
Yes.
Ms. Roseland.
Yes.
Ms. Otto.
Otto.
Yes.
Ms. Rajan. Yes. Chairperson Hilton.
Yes.
9 in favor.
Thank you. So we now turn to the vote of the March 25th public meeting. Are there any corrections or comments to these meetings, to these minutes?
I
Okay.
do have one question. In the minutes early on, we discussed the issue of handling and tracking scheduling if Oath were to pass that to us. And in the March minutes, Chairperson Hilton agreed on page 3 and asked the staff to circle back to Oath to discuss this in a little more depth and report back next month. So I'm curious when we might get a report on that question and how we would handle the logistics.
I thought that was
Okay,
touched on last meeting. Was it not? Kevin,
Yes,
like,
for the notice, the notice that Oath has been handling for us, but should we have to take it over, how that might go? Is that the
Yeah.
topic?
Yes.
Right. We covered it last month, and I'm happy to cover it again in my executive report
Okay, thank you.
for now.
very good. Without any other comments or corrections, can I have a vote on the minutes? Can I entertain a motion to accept minutes?
I move.
Mr. Bowers, second. Rosalind, is that you indicating, or Mr. Roche?
Second.
Mr. Roche is second. Thank you, all board members.
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Hayashi.
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
9 in favor.
Thank you. Thank you for your patience. Now we'll turn it over to Kevin for his executive director's report.
Good afternoon, everyone. Thanks for joining us today. I'll make my first two items, the items that Mr. Delaney mentioned. With respect to enforcement, you're correct. Our enforcement attorney is back. We're very, very happy to have him. And what we've been doing is we've had a scheduled weekly meeting, and we haven't missed one yet, that's focused exclusively on enforcement, largely getting myself up to speed on things and pulling up some old documents that laid out some plans. There's a wonderful presentation prepared by Mr. Argos' predecessor that we're working from. And some of the topics that we're covering week to week are some of the owner defenses that are baked into the rules, and how we can address those, both in combating those defenses if necessary, but also potentially just avoiding having to confront those defenses in the first place. There's a conversation about I think it was called cooperative compliance. That wasn't quite the phrase. It was the meaning of it was ways to try to communicate, warn, advise, perhaps collectively to the owner community in ways that they can avoid enforcement altogether. And then when it comes down to doing enforcement, there's quite a bit of discussion about the venue. Again, I'm getting debriefed week by week. Last I understand is Oath Trials is the venue, and for reasons that we're sussing out whether or not that is the best venue, whether Oath Hearings is an option. So these are the active discussions that we're having on enforcement.
Okay, I guess in follow-up, I would ask two questions. The first is, as you've discussed the tools that are available, the Article 7C, the Loft Law, does have a provision that allows circumstances where either the board or tenants in the building could bring a motion for specific performance. Have you discussed that?
I have seen it. We haven't discussed it, but I will gladly put that on the next enforcement meeting agenda.
I would appreciate that. For those newer board members, and I'm talking in rough figures, under the original loft law of the 80s, there were about 900 buildings that registered as INDs. There are still about 200 of those buildings that have not completed the process, and maybe they're waiting for the 40th anniversary of the loft law next year. Maybe not, I don't know. But while, what was the term you used? Constructive compliance?
Cooperative compliance? Something like that.
Cooperative compliance. While cooperative compliance sounds like something that would be a wonderful vehicle if it works, at some point, there are a few really egregious owners out there. There are owners who haven't registered their bloody building in 10 years. We don't know if we have the right emergency contact number for them. So at some point, it would seem to me that the board might entertain um, using the stick of specific performance in a building or two. I know it's arduous, but it's never happened in close to 40 years. And particularly, there are owners that are out there on the field doing the exercises, but there are some that are still sitting in the locker room. They haven't even showed up on the playing field. So at some point, how long, and if they get away with it, what message does that send to everybody else?
Thank you for flagging that. I've written it down.
Thank you.
Did you have a second question about enforcement also?
I did, but I got so upset about the first one, I forgot the second.
Okay, if you want to circle back, be my guest.
I'm sure it'll go.
All right, thanks.
I remember it now. Thank you very much for reminding me. At the time that memo by the former enforcement counsel was written, there had been kind of a select group of buildings designated for heightened scrutiny, or maybe cooperative compliance. I don't know what have you reviewed that list, and is there any good news out of that?
No, I haven't reviewed that list. In fact, I'm going to find that list now that you've mentioned it. It's possible it got to me and I didn't recognize it for what it is at the time, but
Okay.
likewise, thank you for flagging it.
Thank you.
One of these days, we'll have a new mayor. And I wonder whether somehow we could put this problem on the agenda for the new mayor or the old mayor to get more enforcement officers. I mean, the fact is that there are so many buildings in the original that still haven't been legalized is really a sham, and I don't know what to say about it. But the only way that could be done is if there were more enforcement officers to go around and to check up those buildings. So do you think that it's possible that we could ask the mayor or the new mayor to give us a little more help here?
I think Kevin is
Kevin,
you are.
what's that, Chairperson? I have work boots. I have a helmet. I don't know if I have the expertise. Look, to the extent I took note of that, as we are trying to, build a comprehensive and effective enforcement plan, that question, comment, and request is going to become part of it. It's obvious that more resources are always better, but it's also more than that. We want to ask for the right resources, and I think that might very well be one of the right resources to try to get. So thank you for that. Absolutely. Anything else on the enforcement updates? All right, thank you. The second thing Mr. Delaney asked for a little update on was, and it was, I believe it was a matter relating to, as we were updating the rules, there is a rule by which the Loft Board, and more specifically the Loft Board staff, is responsible for service of documents that in the pendency or before an oath proceeding. And as in real life practice, Oath has very kindly and efficiently and with a great appreciation been doing that. And the question, we couldn't change the rule to say they should do it from now on. That's not something they were willing to accept. And so appropriately, the question arose, so what happens if and when Oath decides they no longer can do this for us? And in sum, I had a very good conversation with the folks at Oath, whom I have, we all have a good rapport, and it was clearly explained that there wouldn't be any, dropping it in our laps unexpectedly. There'd be a conversation with a lead time, providing of drafts and documents to use, and that there was a very crucial piece, Mr. Delaney, I remember you were interested in, and I want to make sure I hit it. But it was that, basically we would serve as the mailing agent, but the arrangement of the schedules would happen by their calendaring unit. We would not be trying to reach out to all the parties to set dates or anything like that. That was the crux of that conversation. If there's any more, I can definitely try to seek that out.
That's good. Thanks.
All right. Okay. other parts of the update, due to the ongoing public health crisis, in accordance with the governor's executive order 202.105, issued on April 27, 2021, the suspension of required in-person board meetings has been extended through May 27, 2021. With respect to revenue, the unofficial Loft Board revenue for April was $950. With respect to enforcement, there were 2 violations issued in April. On April 2nd, 1 violation was issued at 73 Leonard Street for no running water in the building. And also on April 2nd, 1 violation was issued at 517-525 West 45th Street for inadequate heat. I have some litigation updates. We have one new, it's not even really a new case, it's a new motion on an old case. The case is called Rasudin Grigola et al., the Cretans Association, Omania Inc., and DOB, HPD, and Loft Board. And in that case, back in 2015, the tenants had signed a settlement stipulation, and they have now filed a motion to enforce that stipulation. And the terms of that stipulation that are problematic are really the landlords. They're not us. We remain a party on paper, but according to Loft Board and by what I've seen, the motion, while we're included as a party, the motion isn't an action involving us in any way or the city in any way. It's seeking compliance on things that the landlord had said they would do back in 2015. There's 3 decisions. One is Robinson et al., the New York City Loft Board. In this case, tenants filed an Article 78 challenging Loft Board Order 4854, which was dated February 21st, 2019, and another order, 4948, dated March 19th, 2020. And the tenants have claimed that they were rent stabilized tenants under rent stabilization law and not the loft law. The orders found that the building was an IMD under the loft law, and the order 4854 refused to reject registration for coverage despite the tenant's protest and preference to be covered by the Emergency Tenant Protection Act. And the second order, 4948, denied reconsideration of that, saying that the tenants failed to show error or denial of due process. And most notably, the board rejected tenants' claim that an informal conference that was scheduled pursuant to Loft Board rules should have complied with CAPA notice and requirements. And the court dismissed their Article 78 petition, finding that the Loft Board's orders were not arbitrary, capricious, or contrary to law. The second decision update is James Gubelman versus the New York City Loft Board, Cynthia Law and Frank Lamb. In that case, the petitioner filed an Article 78 challenging Loft Board Order 4819, denying coverage and protected occupant status because the tenant failed to prove that one of the 3 units occupied during the window period had a front-facing window that was required, front-facing a street, a yard, or a court. And Mr. Gubelman was permitted to withdraw his petition as moot, ultimately, because he reapplied for coverage under new standards that were amended and made retroactive in 2019 loft law updates. The third case is Nazer and Mickle versus the New York City Loft Board and Sydney Saul Group Limited. In that case, petitioner were tenants of 544 West 27th Street in Manhattan, and they filed an Article 78 seeking an order to compel the Loft Board to reconsider their application a second time. It had already been reconsidered once, and they sought another consideration. And these tenants had unsuccessfully challenged 2 Loft Board orders in a prior Article 78, so this one was to compel another review. The Loft Board orders at issue accepted an oath ALJ's recommendation and denied their application seeking coverage and protected occupant status because the either tenant resided in the building for 12 months, 12 consecutive months during the window period in 2008 and 2009. And the second order that issued reconsidered, but also denied it. The court dismissed the tenant's Article 78 in this situation, finding that the loft board's denying a second reconsideration was rational. It was not arbitrary. It was not capricious, contrary to law. So those are the litigation updates. And I have one more update that relates to some legislation that I found out about yesterday. So I really just want to flag it for everybody and let them know. So give me 1 minute to find it here. Oh, there it is. It's from the State Assembly. It's bill number A07667. And it's changes to the multiple dwelling law, or proposed changes, I should say, to the multiple dwelling law 282. And I'm just going to read it as the description gives it. It would require owners to provide essential services and habitability for interim multiple dwelling units and allow occupants of interim multiple dwelling units to bring an action in a court of competent jurisdiction. This adds on some rights and protections for tenants insofar as potential action for essential services and habitability issues in IMDs. And within the language, it discusses specifically for these issues being able to bring them to the New York City Civil Court housing part. So there's more to learn about this. Again, I've told you about all I know about it at this time, but I did want to flag it for everyone because it's obviously very, very pertinent to what we do. That is everything I have for the Executive Director's report.
Questions for Mr. Schultz?
Kevin, in terms of that last legislation you're discussing, do you know who introduced that?
Yes, it was Glick. I believe it's Ms. Glick, and I don't have her first name, but
okay.
Assemblywoman Glick.
Assemblywoman Glick.
Deborah.
Deborah, yes, thank you. Deborah Glick.
Is she Manhattan or Brooklyn, Chuck? Do you know?
She's Manhattan, Greenwich Village, down to Soho, up a bit into Chelsea.
Yeah.
All right. I think Chuck had something.
Yeah. I do have a couple questions, Kevin. First off, with regard to that new motion in the first case that you recited where the tenants signed a stipulation in 2015, I didn't get the name of it. Could you send me the papers on that, please?
Certainly, yes.
Okay. Second, further on your report, can you give me the street address for the first case you reported on, Robinson et al.?
I could give it to you later because I don't see it in my notes, and it should be there. If anyone on the staff can get it before the end of the meeting, I'd appreciate it, and I will try to look it up as well and get it to you before the end of the meeting. I should be able to.
I believe that address is 47 Thames Street, Brooklyn, New York.
47 Thames.
Thank you, Tina.
Yes, a rare building that doesn't want to be covered by the loft law. Now, I do have a couple of other questions on topics that we have not touched upon as yet for you, Kevin. First and foremost, on Monday of this week, the City Planning Commission certified a ULURP item relating to a proposed rezoning of Soho and NoHo. And this comes after a long period of discussion that originally began with community meetings, and it has some impact on the loft world because of the artist-only zoning in Soho and NoHo, the number of IMDs in Soho and NoHo, and in fact, the former executive director and counsel, Ms. Balsam and Ms. Cruz, attended a number of those community meetings. I just wonder what and how the board has any intention of playing any role or staying informed or briefing the board members on that topic.
Let me add a thing to what Chuck just said. I got very involved and was on several committees in the new zoning. For example, last week in the Daily News, there were two long articles on the more or less op-ed page, whatever it is in the Daily News. One by an architect supporting the rezoning of Soho and NoHo, and another by a housing group that was against it. Interesting, neither of those articles, and they were all, I would say, quite lengthy. Neither of them mentioned artists. And it begins to sort of grieve me, since that community was, at least the Soho community, was made by artists. And I am getting to the point now where I just, whatever I seem to say, it doesn't seem to matter. I sent 2 long letters, not identifying myself as a member of the Loft Board, to the Department of Planning, and got no response. So I think that we have a somewhat uphill battle here for the recognition of artists and others that live in lofts. And I just hope that we can make ourselves known, because also it was really quite clear the last Zoom meeting that I attended on Soho NoHo that most people had no idea what the loft law is, who it covered, and why. And that's really just too bad. I don't know what else to say.
Thank you, Ms. Bowers. Okay, we want to move on. Is there any other quick comment? Thank you, Kevin.
I'm sorry, I don't think I got an answer to my question.
Oh.
And I have another one as well, but.
Sure. I mean, I'll answer by saying personally, I've got to thank Mr. Borowitz. Within my first, I think, second or third day of being in this position, he forwarded me a meeting that was one of the public meetings, I think one of the bigger ones, and I was able to join it and listen in. And so, to the extent that I and we are staying abreast of this, that certainly is true. Insofar as providing updates to you, I can certainly confer closer with the staff as to get personally a better understanding of the interaction. And I know there is some plenty of interaction between what we do and this and the rezoning, specifically insofar as impacts that we can update you on. Please allow me to confer with the staff on that, and we will.
So perhaps you could provide us with an update next month.
Certainly, yes.
Okay. And my last question regarding the report is an expression of concern with there's an old saying that any road will do if you don't know where you're going. And the Loft Board has really fallen down, in my view, in providing members with statistics. back 8-10 years ago, this was a regular quarterly report. And we got a few of them, but the last one's probably like 2 years old. And without knowing, I mentioned earlier the fact that of the 900 or so buildings that originally registered under the original loft law, there are 200 left in the system. The reports we used to get would tell us how many buildings are in our jurisdiction, how many are under 286, 281, 281, 5 and 281, now 281.6, where they are. It would identify how many where the landlord hasn't done anything. It would tell us how many had reached a TC of O, how many had obtained permits, that kind of information. And without those kind of key performance indicators, the road we're on is fine because we don't know where we're going. Similarly, we used to get a report of how many cases are pending based on flavor, how many coverage, how many legalization, and all that has kind of disappeared, which is a real concern to me. And I think with new board members, a lot of relatively new staff members, it's time to get back on track with that. Because, for example, we often hear the argument that the loft law doesn't work and no buildings are being legalized. But in reality, we did, I don't know now because it's been over a year since I've seen any figures, we had a significant number of buildings that had reached certificate of occupancy, a number of them that had filed LE cases, removal cases. So we had more buildings that had really finished the process except for getting their exit visa than was evident in the stats. So I think it's time that has to be, we have to find a way to provide that kind of reporting once again. So I guess my question to you is, would you take a look at that and also update us about that at next month's board meeting?
Yes, I will work to get my hands on one of those reports you're referencing and see what can be replicated. And if I can't find it, I'll reach out to you to see if I can make sure I know I'm looking at what you're talking about. My guess is I'll find it.
And if I can certainly rummage through the old downloads of loft board materials and supply you with some of them. The stats that were provided some years ago were better than the most recent ones, but anything is better than nothing.
All right. I know our staff are excellent record keepers, so I have pretty good faith I'll find what you're talking about.
Yeah, and we have some of that stuff already. Kevin, Ms. Rivera is kind enough to say she knows that she has it. So previous reports, and thank you for that, lady, for flagging that. I think we got a little side step there with rulemaking for the past a couple of years here, and that has lost our consciousness. But yes, we do have some information that we can share up, actually, so we can do that. Yeah, quarterly, is that quarterly? You know, we'll come back and we'll talk about it staff-wise. But I hate to do this every month. I mean, it would really be a little bit too much in terms of taking up meetings, but we could certainly plan it quarterly.
Exactly. In the same way that we, in the proposed rules, are easing the requirement of owners to file legalization updates once a quarter rather than once a month. We don't need these every month by any means, but quarterly would be wonderful, and we could see how we're doing.
Right. Thank you. Okay, I take it there's no more questions for Mr. Schultz? Hint, hint. Okay, great. So So the floor is yours, Mr. Delaney, regarding self-certification.
Oh, okay, I didn't realize that was the order of going.
Did you want to delay a little bit? I could go to cases.
No, that's fine. That's fine. I just I hadn't looked at the agenda in that much detail. Once again, particularly for the new members of the board, several years ago at this point, a former board member, Julie Torres Moskovitz, asked for a meeting with the sort of Department of Buildings expert on a series of topics. Mr. Rebholz, I believe, is that correct? Martin Rebholz?
Yes, he's a deputy commissioner.
Yes. And in particular, there have been some loft buildings that have been able to make progress through the legalization route in the Department of Buildings in ways that make no sense, and in some instances, I think demonstrate kind of flagrant abuse of the system. There's a building that, and I didn't have time to pull the specifics for this meeting, but there's a building where the owner applied to legalize 20 units, but got a certificate of occupancy for 40 units. And it's still, and there have been cases in litigation and all kinds of stuff. There's another building that got a certificate of occupancy, 255 18th Street in Brooklyn, that got a certificate of occupancy despite having basement units, which should have never been legalized. And that led Ms. Moskovitz, who, like Heather Roslin, is an architect, to question the role of both professional certification and self-certification in the process. And that's not to imply that there are a massive number of landlords who would resort to extraordinary and questionable tactics to make progress through the loft law and bring a building into compliance. But it has always been the case since the 70s that the loft world, because back in those days there was no regulation whatsoever, seemed to be more attractive to people with questionable intention or who were willing to utilize extraordinary means to get around the normal routine. And what we learned from Mr. Rebholz is that first, the distinction between professional certification and self-certification, all of which is summarized much better than I can by comments from Heather and former member Julie Torres Moskovitz. And I want to say it's the November 2020 and the January 2021 minutes. And what we learned from Mr. Rebholz was that about 20% of self-certification advancements that are given get audited by the Department of Buildings. They also audit self-certification.
Professional certification.
Professional certification. They also audit professional certification if there's a complaint raised. And the question came up, and it turns out there's quite a few of these. So if the question came up, would it make sense to for the board to express a desire to the Department of Buildings that review of professional certification be routine for IMD buildings, since there does seem to be, there are at least half a dozen instances of stuff that just shouldn't take place. Many years ago, there was a building on Beach Street, 4860 Beach Street, an IMD building. The owner got a certificate of occupancy for the building, even though it was over 5,000 square feet and would have needed a certification in Tribeca to accomplish that. Boom, the owner just got it. The tenants had to hire a law firm to go to the Board of Standards and Appeals, along with the city, to ask that the certificate of occupancy be revoked, which it eventually was. And the Department of Buildings employee who had made that magical certificate of occupancy appear was dismissed from the Department of Buildings for that activity, and was back the next week as an expediter. So the Department of Buildings has made a lot of progress since those days, but still there's just something about the opportunities in loft buildings that seems to attract a measurable percentage of people who don't want to play by the rules. So the question is, should self-certification in loft buildings be subject to automatic review, and would that help keep the kinds of things that happen down going forward in the future? And this has been something that we've talked about multiple times, and I have opted not to press forward because I don't think it's fair to have someone, in this case, Ms. Otto, say, "Hi, it's your first meeting. Make a big policy decision." But I think I've been deferring it now for 3 or 4 months, so I would think at least some discussion would make sense. And then if there is interest on the part of the board, then I'd be happy to whip up some kind of resolution or go back and provide some more detail of cases of the kind of abuse we're talking about. Period.
Thank you. Thank you, Chuck. Right. So I just want to be clear. So when Chuck says 20% of self-certification, he means, I think the department audits 20% of all self-certified jobs. That's
Professionally certified.
Professional certified jobs. Okay. Just want to make it clear on the terminology. Okay.
And I would add that it's not just the issue that a building owner might hire an unscrupulous professional to get a building through the buildings department, that it's also the nature of the beast with spaces that have been built out without any forethought, without a team of professionals, without licensed contractors. It's sort of, it's everybody who's involved in the construction of a loft, is at play here. So so when a professional is then, certifying to the Department of Buildings that this building is legal, there's so many places there's so much room for error, and it's such a morass that to have someone just say that it's okay without there being any sort of review or scrutiny is where the focus of the meeting really lay.
I would say that we also we need greater scrutiny in terms of what qualifies for self-cert. Not everything qualifies for self-cert. So what instances are we talking about in terms of what was cited in the letter that we looked at? That was many years ago discovered by Department of Buildings of a specific architect on multiple sites, and was remedied. So are we looking for an issue or is there genuinely an issue here that requires addressing? Has there been, several cases of architects since then self-certifying and Department of Buildings issuing violations and suspending architects' licenses and things of that nature? Have we seen that around? And also, there's a specific group of architects who typically work on loft buildings. Have we seen that amongst those practitioners? I want to be clear as to like what's being proposed and what remedy is being proposed, and to what result.
Well, no one is answering, so I will just say that I don't believe this debate right now is going to happen. Correct? From what my understanding is, let's think about it. Come back, Chuck, for the debate. Is that what you're suggesting? Because we really don't have the time to delve into all this debate today.
I think the questions Christian raises are good questions, and it's certainly true that this is a relatively small universe of architects who deal with these buildings. And the answer to how prevalent are the problems, the answer to that is, I don't know. What we hear about are the most egregious ones that surface. I suppose perhaps Kevin may have some sense based on his prior role at the Loft Board, at the Department of Buildings. So my interest was really to get a sense from other board members whether this was a topic that merited some research and study to proceed or not.
I certainly, as far as knowing, how prevalent the problems are, it's something I could look into. I think I know who to call, see if there's anything about that. So certainly.
And Heather makes a very good point that the circumstances in loft buildings are complicated by the fact that they've been built out often by artists, craftspeople, tenants, who may or may not have a thorough understanding of code. And now the owner is being asked to legalize the unit with the tenants in place, which is quite different from construction of new housing where nobody moves in until there is a certificate of occupancy. So those are kind of the issues as they are.
I want to make something clear, and I know there's always room for errors and stuff, and sometimes misdeeds, but before any certificate of occupancy is issued by the department, there is a final construction inspection. And I leave it at that. I did say there's always room for error and misdeeds, but there is a final construction inspection done by a department employee to make sure that what is on the certificate, what's on the construction documents should be what is actually in the building. Chuck mentioned some anomalies there, but I'm just letting you know, process-wise, that's what occurs. Okay. All right. So Chuck, thank you. We just need to move along, but I suppose I just want to make it clear as what we're doing with this. Next month we come back. We want to allot maybe 15 minutes for discussion on this. Is that what you're saying, Chuck?
Sure, I think that's fine.
Okay, great. Thank you. So, in the interest of time, let's move on. So we're going to thank you very much, Chuck, by the way, for that presentation. Next on the agenda is the matter of Next on the agenda is a vote on the cases. Our votes on cases, and the appeals and reconsideration calendar is the first one. There's one case on the appeals and reconsideration calendar, and that is 16 Cypress Avenue Realty, LLC. The address is 476 Jefferson Street in Brooklyn, and the docket numbers are 0385. Ms. Lynn, she will present this case.
Thank you, Chairperson. Case number 1 in the matter of 16 Cypress Avenue Realty LLC is a reconsideration application filed by the owner of 476 Jefferson Street, Brooklyn, New York, which seeks reconsideration of lawful order number 4995, dated July 16, 2020. Lawful order 4995 granted protected occupancy status to the current tenants of Unit 306 at the subject building, finding that the unit was not deregulated through sales of lawful rights by prior tenants. Owner now challenges lawful order 4995, arguing that the law board erred in finding that the sale of rights by prior tenants got leased was invalid. First, the proposed order finds that the owner was not denied due process due to the current tenant's failure to amend its pleadings to specify that the lease sale was invalid. The validity of the sales agreement is an affirmative defense to be pled and proven by the owner. Second, the proposed order rejects owner's assertion that a sale of rights does not require an analysis of whether the selling tenant has knowingly waived his rights. Owner argues that MDL 28612 should be read in 2 parts, and that waiver of rights only applies to agreements made prior to lawful's enactment. Owner did not offer any legal support for this interpretation. The law court has long interpreted a waiver of rights as a necessary analysis in determining whether a sales agreement is valid. Third, the proposed order finds that there was no error in the underlying order's finding that Scott Reese did not effectuate a knowing waiver of his lawful rights. The sales agreement signed by Mr. Reese did not reference the lawful or the multiple dwelling law. At trial, Mr. Reese had testified that he signed the agreement in order to receive his security deposit back, and the presiding administrative law judge credited his testimony. Owner alleges that the law court should find the resale agreement valid because the registration application was mailed to Mr. Reese around the time when he signed the sales agreement, and that he had signed the sales record form 6 months after he vacated the unit. The proposed order finds that these circumstances are insufficient to demonstrate that Mr. Reese intended to sell his rights at the time he signed the sales agreement. Therefore, the proposed order rejects the owner's reconsideration application.
Thank you. Thank you, Ms. Lynn. Is there a motion then to accept this case? Delaney has indicated. Is there a second motion, Ms. Rosalind? Thank you. Then are there any questions or comments on this? Excuse me. Are there any comments on this case?
Yes, I had mentioned to my colleagues in the private session prior to the public meeting that this is one of several cases on today's agenda that deals with the desire in many instances of owners to present something as a sale of rights document pursuant to Section 286.12 of the multiple dwelling law, and that this is an area that's become quite a headache for the law board in terms of litigation around it and teasing out what is a legitimate sales of right document versus what isn't.
Thank you. Any other comments? Without any comments, Mr. Rivera, could you please poll the board members?
Mr. Barrett,
Mr. Barrett is no longer on the board. He left the board. He had to leave early.
oh, okay, no. Okay, Mr. Roach,
Mr. Roche.
Yes. Yes.
Ms. Dashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Otto,
Yeah.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 absent.
I just need to clarify for Mr. Barrett that he was part of this meeting before, but he had to leave and to attend to a family matter. So he's not really he's absent now, but he was present previously in this meeting. All right. Thank you, Rivera. So there are 4 cases on the summary calendar, and they're voted on as a group. These cases are 222 Barrett Realty Corp., and the address is 222 Barrett Street in Brooklyn, New York, and docket number is LB0195. The other case is Tamar Halpern, and it's 144 Spencer Street in Brooklyn, New York, and the docket numbers are P0090 and TA0256. The other case is Marie Estrada and Eric Jacobson at 473 through 493 Kent Avenue in Brooklyn, and that's TR 1385. Last is Masay Jasic, saying that right? Masay Jasic at 1609 DeKalb Avenue in Brooklyn, New York, and that docket number is TR 1391. Do I have a motion to accept these cases? Board members? Ms. Rajan is
So moved.
Ms. Rajan is moved and Ms. Roslin has seconded. Sorry, Mr. Hilton, I was looking at Ms. Roslin's hand up. Okay. Ms. Do you have any comments on these cases? Mr. Delaney has indicated.
Yes, in the private meeting, I did indicate that I wanted, just mostly for the edification of the board members, the new board members, to make a couple of comments in the public session that weren't really appropriate for the private session. This case at 222 Verrett, number 2 on the agenda, is an abandonment application where the owner withdrew the motion for abandonment. And just so you're aware, we haven't seen a lot of these recently, but the concept of abandonment came up out of the idea, which seemed pretty unusual at the time, that a tenant would just leave a protected unit, but by leaving, the tenant's not there, but the unit's vacant. What can the landlord do? Can the landlord rent it to somebody else? If so, is it still at the protected rent? Does the owner have to legalize? So over a number of years, the board developed a theory following a court case. And the court case involved a tenant who left his unit, but he, at the point of his departure, owed the landlord some amount of money, several $1,000s, as I recall. And the owner went to court, and the court judge determined that what had happened is that the landlord had made what the judge called a constructive purchase of fixtures. There's another section of the Loft Law 286.6, which posits the idea that an outgoing tenant can sell their fixtures to an incoming tenant if they're first offered to the landlord, who has the right of first refusal. But this tenant just blew town, owing some back rent. So the judge said, well, basically, you purchased the fixtures, so the unit's deregulated. That led the board to craft an abandonment regulation, which attempts to address the issue of what happens when someone just leaves. It got out of control, particularly in the 1990s. The Loft Board had a case where the tenant of a given unit in the East Village was shot and killed in a robbery in front of his own building. And the Loft Board somehow concluded that he'd abandoned the unit. And that was following a logic that death in a unit could equal abandonment under certain circumstances. The abandonment rule has been cleaned up quite a bit, but there still is this question, which we saw here, where one of the big issues is how vigorously the owner attempts to locate the person who's allegedly abandoned. And we've run the gamut from owners doing a lot of work and finding somebody, and lo and behold, they did really abandon, as opposed to the owner just didn't file notice to the tenant. The tenant pops up and says, I'm here. I'm living right where I was. I haven't abandoned anything. So there's kind of a wide range of cases, but this one seems to be in the process of resolving itself. But I promised you all that I'd spend a few minutes covering the thumbnail of the history, and that I've done. Thank you for your patience.
I appreciate that, Mr. Delaney. Any other comments? You did a good job, Mr. Delaney. So then now we'll have Mr. Rivera call the board members, please.
Mr. Roach,
Mr. Roche.
Yes.
Ms.
Yes.
Hayashi,
Hayashi.
Hayashi,
Ms. Hayashi? Ms. Hayashi? Okay. I see she's looking at me, but Ms. Hayashi? No. Okay, let's skip over. And
Mr. Hilton,
Yes.
Mrs. Delaney,
Mr. Delaney.
Yes.
Ms. Roseman,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
I'll go back to Mr.
Ms. Hayashi,
Ms. Hayashi, can you hear me? Can you hear us? Miss, could you go ahead and just call me again?
Mr. Hilton,
Yes.
Chairperson Hilton.
Yes. Do you have a more majority?
Yeah.
How much?
1, 2, 3, 4, 5, 6, 7.
So that's seven.
7.
One abstain?
Yeah.
Okay. So that's
One abstain.
that vote. Ms. Hayashi, are you there? Okay, so we'll call that an abstention. So you have 7.
7 in favor, 1 abstain, and 1 absent.
Thank you. 7 in favor, 1 absent, 1 abstain. Thank you. There is one case on the master calendar, and that case is Julian Bozeman at 473 through 493 Kent Avenue in Brooklyn. The docket number is P00075. And Mr. Schultz will make a short presentation in this case.
Case number 6 relates to IMD number 30080. In 2017, tenant, Mr. Bozeman, at 475 Kent Avenue, filed an application for protected occupancy status. Later in 2017, the Loft Board transferred that application to the New York City Office of Administrative Trials and Hearings, OATH. A trial was held, and the administrative law judge recommended that the application for protected occupant status be denied. In 2020, June of 2020, the Loft Board rejected that ALJ's recommendation and granted protected occupant status. The owner filed an Article 78 to annul the Loft Board's order, arguing, amongst other things, that the board had failed to consider certain post-trial briefs that were submitted after the oath trial. And this order calls to vacate that prior order and remand the matter back to the Loft Board itself in order to ensure that all the relevant documents and briefs have been reviewed in the order.
Thank you. So due to the nature of this case, there will be no discussion. Is there a motion to accept this case? Ms. Rajan, is there a second? Thank you, Ms. Otto. And Ms. Rivera, could you please poll the board members?
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseman,
Yes.
Ms. Adam,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 absent.
Thank you, Ms. Rivera. So this ends our cases for the evening. I will now turn this matter over to Mr. Schultz to lead the discussion on the rules.
Hello again, everybody. So we're on to rulemaking, and this conversation today is a cleanup on a few comments from last time, flagging a few things that were changed since the last time we met. And so I'm just going to work my way through those. I think all together, if that's okay. No, maybe I'll pause at each one. No, I'm going to go through them all. Try to save questions for the end. If you have a burning question and want to raise your hand or speak up, please do. Otherwise, I'll work top to bottom. Last time we met about rulemaking, there were some questions about table of contents. The draft that we've been working with had removed table of contents, and as promised, I conferred with the law department on why that was done. And the answer is that essentially, regularly for them in rulemaking, they've recommended that tables of contents are unnecessary, and for modern use on computers, people's rules, they have use of rules, they have links that essentially create a table of contents, and those aren't in the rules themselves. Including them in the rules themselves, as the law department said, it creates another area that requires review and editing. So for that reason, they, as a practice, have been removing tables of content. The second note I wanted to make was that the statement of basis and purpose for the proposed rule was edited. Specifically, Section 3 was edited. Conversations over the meetings, we've talked about the scope of that, and that section has now been revised to really just reflect what's essentially the ministerial and form changes that have been made, as the content changes for the most part were entirely or almost entirely were removed. Another note, there was a question last meeting about Housing Stability and Tenant Protection Act conformance, and there's a request that we review the language, certain language in the new rules, and make sure it conformed with that. And we have done that. And the HSTPA changed a four-year timeline to a 6-year timeline, and we did the same. So we do comply with that. A few other items that changed that I think relatively minor, but would want to flag them. On page 64 and 65, we changed the word monthly to quarterly in a few occasions because the reporting requirements have changed from monthly to quarterly in another section. So that's just for consistency of that change. On page 96, there's a chart that describes the temperatures by which an owner must provide heat. And with the changes in the 2019 rules, I believe there was a notation of below 40 that was there before, but now there is no floor, there is no minimum there. And so rather than leaving the box blank, which the edits just kind of did, we've added a suggested language, just adding any temperature. At any temperature, in that situation, the owner must provide heat, and it's a certain date range. It's on page 96. Pages 122 to 124 removed some section labels. It was for formatting on some renumbering, some periods where they weren't supposed to be. Page 125 moved a bracket over to delete section G that doesn't need to be there anymore. And pages 171 to 172 capitalize the word prime lessee. It's a defined term that's been used. So I'll pause there for comment or question on any of that, and really anything else. If anyone is talking, they're on mute. Maybe there are no questions.
That was me talking on mute. So I just, first of all, I want to congratulate staff on this document, which I thought just was looking so nicely professionally done, put together, and in ready format to go forward, and for the time and effort that was put in over these last 4 years or so. I could even, I know I'm not underestimating or even exaggerating. I'm sorry if I say 4 years. It's been a long stretch, and we do have come to a point now where we have a document that is good and ready to go. I believe that improves upon the current rules so much, and you know, not just improves on, but it actually accounts for a lot of changes that needed to happen because of legislation. I want to thank the board, you know, past and present folks who put in a lot of time into these rules and you know, trying to figure things out. They're not. I don't believe we have. Well, now we do have a lawyer on the board, and it is not easy. You know, as a non-lawyer, for me, particularly I kind of understand this, and I know Mr. Delaney is. You know, what are you, Mr. Delaney, a Philadelphia lawyer, or is that what they call you? But yeah, is that, but yeah, I mean, this has been quite a bit of work, and we're now ready to at least give the law department a stab at giving us preliminary approval so we can get public comments and to get a final rule in hopefully soon after. So I just, my heart goes out to everybody who has been involved in these rules. Kevin, I even want to thank former executive director Balsam, and for her stab at starting this, and such a good job in getting this. And you know, she in her heart she wanted to get this done before she left and retired. And now Kevin gets the praise for this. But all right.
Well,
But,
maybe I'll share what I shared before. This is like getting to start the New York City Marathon somewhere in the north part of Central Park and cross the finish line. So,
right.
you know, very little credit to me. This is a long time coming.
So if you want to stay on the marathon analogy, then we just want to get through the finish line with this. And I think we're almost there. And I appreciate everyone's thoughts, comments, input, hard work, research, writing, editing, that kind of stuff. Everything that that went into this it wasn't easy. So thanks again. So I'm going to, at this point, without it, if no one has comments. Yes.
I have a couple of, yes, I'm sorry, I have a couple of questions. First off, going back to the table on page 96 with regard to heat, that's not something I've been thinking about. How do the figures that we have in here now for our minimum housing maintenance standards compare with the standard heat law for the city?
I do not know. If anyone in the staff does, welcome them to pipe in, and we could certainly try to do some research literally immediately.
I
do know that this.
It matches. I believe this is why it was originally taken out in the first place. It was reflected. It was changed to reflect the updates to the housing maintenance codes.
Because that was raised from nighttime heat between 10 and 6 a.m. from 55 to 62 a few years ago. Am I remembering that correctly?
Something like that.
Okay, and yes, thank you. And similarly, the any temperature, if the temperature outside is any temperature, that requires the heat inside be 62 degrees Fahrenheit, whereas during the day, the provision is that it has to be below 55 to require the heat to be at least 68 inside.
So this
Yeah.
is in terms.
So we're saying any temperature, you got to be at least 62, but during the day, it's a different. There is a minimum temperature.
Yeah, during the day there's a minimum temperature can dictate what the landlord must provide, but at nighttime there is no temperature that dictates that the landlord must keep it at 62 degrees.
Right. So, I think the idea here is it doesn't matter what the temperature is outside at night when you're sleeping. It matters what the temperature is on the inside.
Yes.
Okay. Any?
There's just basically an unequivocal expectation for the landlords at night to keep it at 62.
Right. Any other questions, comments on these rules?
Well, I sort of wonder if that will change a little bit after the last year, because a big presumption of the daytime temperature is that people are not in the apartment during the day, right? But now that everyone has worked from home for a year and a half, it may change.
Yeah, very possible. But we just hope that that was a temporary setting, and we're out of it. Any further questions, Mr. Delaney? Was that
just a couple more in terms of how we proceed? Can you just, are you looking for us to vote to send this to the law department?
Yes, sir. We, Kevin, I think, yeah, it's okay. Okay. So I think the next step, Kevin, just please hit me in my non-lawyerly mouth if you don't mind. But yes, the next step would be your vote, board approval, to send this to the law department for preliminary approval. It's going to come back to you if they're, well, it's going to come back to you one way or the other. If the law departments feel that there is stuff to be done, that are what's the word? Substantive changes to the rule, is going to have to come back to you for vote and changes on discussion and vote to send it back to them for another approval. If there are no substantive changes, then they will send their preliminary approval with, if there are ministerial changes, with those ministerial changes. That would start the comment period, at which point you'll have public hearings. Then it'll go back after you've voted on if you decide not to make, let's just go what we call the happy path, where there's no changes. Then it goes back to the law department for final approval, and then you have a 30-day window before the rule takes effect. If there are hiccups in between, where it could be going back and forth to the law department.
Not to belabor the point, but just so I'm clear, because it's been a while since, as you pointed out, it's been 4 years we've been working on this rule. It goes to the law department. The law department comes back and says there's a change a must to a shall or whatever, a couple little changes. We then vote it out to be published, and that starts the comment period, correct?
Yes.
So,
you have to, it's not final publication. Right? It has to be published, as a draft rule, and then comment period, yes.
Yes. It gets published as a draft in the city record, and that publication in the city record also triggers the clock for public comment, and we will hold a public hearing, correct?
Yes. And after that public hearing, you may, as a board, decide you want to change something or not. And
right. And it would then come back to us for discussion, maybe some changes. If the changes were substantive, it would go back to the law department and then come back. But after the appropriate comment period, at some point, we would vote to make this official.
Yes, that's right. And then after that, it has to be posted, published for 30 days before it takes effect.
And so my last question is, the draft that we have in the notice of public hearing posits that that's going to be a virtual hearing, but it seems to me quite possible by that time the open meetings law may be back into effect.
That is actually my hope. I don't know about you, but that is actually my hope.
Right, so that would require just changing the opening notice.
Yes, yes, that's absolutely a good note. You know, and it's a little hard to tell right now, but I agree with Chairperson. We hope to be able to do it publicly, and I don't know if I'll be so bold as to say expect, but it certainly seems hopeful. So yes, that language would have to adapt, and I believe I've seen what that language looks like because this started before these hearings were teleconferenced.
Any other comments? Any questions for Mr. Schultz? So again, I just want to say thank you without saying thank you too many times. I do want to say thank you. I lost my place. 1 second. There it is. Okay. So the last item on the agenda concerns an active litigation matter against the Loft Board. The matter is Deezer Properties 2 LLC versus the New York City Loft Board. Pursuant to the Open Meetings Law, Section 105, a public body may conduct an executive session to discuss proposed, pending, or current litigation. At this time, do I have a motion for the board to go into executive session to discuss litigation strategy in the matters of Deezer Properties 2 LLC versus the New York City Loft Board and to related strategy for future similarly situated cases and the relevant proposed litigation?
Chairperson, did we vote on the rules?
Oh, no, we did
entirely?
not. We did not. I was so thankful for everyone that I thought maybe that came with an automatic unanimous decision to go. So I'm sorry. Let me go back. I won't have to read this again, hopefully. But let me go back to a motion to accept these rules as drafted and to be sent to the New York City Law Department for preliminary approval and to the, I believe, to the Mayor's Office of Operations for a look over. Do I have a motion on the rules?
I make a motion.
Thank you. The fire department makes a motion. That's your start. All right. Mr. Delaney seconds. And then, so Ms. Rivera, could you please poll the board members?
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland, Ms. Roseland,
Yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor, 1 absent.
8-1. You know, I have to say this. This must hurt Mr. Borowitz for not being here to vote on these rules. Okay. Anyway, I'm not going to necessarily repeat the reading that I just made, but do I have a motion then for executive session to discuss the Deezer Properties LLC, Deezer Properties 2 LLC versus New York City Loft Board matter?
So moved.
That is Ms. Roslin. Am I correct?
Okay, it's Kay Hayashi.
Oh, Ms. Hayashi. I wasn't looking. Sorry, Ms. Hayashi. And who's second?
I'll second.
Rosalind, thank you.
Since you're
Ms. Rivera, could you please poll the board members?
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Hilton,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
yes.
Ms. Otto,
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton.
Yeah.
8 in favor, 1 absent.
Thank you. So I have a certain instructions to read. Just bear with me for a second. So the motion passes and we will go into executive session after I am finished speaking. I'm not finished yet. So when I'm finished speaking, I will ask the members from the public to sign off so that the board may go into executive session to discuss this matter. This will conclude the public session of our May 20th, 2021 board meeting. As a reminder, our next public meeting will be held on Thursday, June 17th, 2021 at 2 p.m. The governor's suspension of the in-person meetings requirement and open meeting law is in effect until May 27th, 2021. So at this time, as usual, we do not know whether the meeting will be held virtually or not. When we have further information, we will update the Loft Board website, send an email update through the Loft Board announcement listserv. I thank you everyone. Board members, please stay on for the executive session. Members of the public, I ask you to log off at this time. Okay, I'm going to start dismissing members of the public. So,
No, I think you could probably stop recording now if we ended the public session.
oh yes, thank you. Oh, there goes again that thing that's not stop recording. It won't happen, but anyway. Members of the public, could you please just dismiss yourselves from this meeting, or I will have to do it individually.
Almost.
I'm almost just, if I mistakenly dismiss any of you board members, please just feel free to come back in.
Everyone's getting bigger.
I can see people's faces.